for the first and second? Or there's somebody on site? Yes, who is it? Coming up? Yes. If you want to run it, you were here in the morning. Yes, we stay in running. And with the Kiome, yes. Brenda, are you there?
Yes, sir.
That's you?
Yes,
Okay. Brenda Gikundi. Samuel? Where is Samuel? Karanja, Samuel, yes. Who is paying your fees? Julius Babuka. You are too many. Yes. For respondent number 3. Yes.
Please, my Lord.
Yes, please.
My name is Charles Mongela.
Mr. Charles Mogera, yes.
My Lord, I have been instructed to appear for the first and the second respondents.
1 and 2.
My Lord, I have not managed to put in my notice of appointment, but I believe, my Lord, when the these proceedings need to be conducted,
Yes.
I kindly beg that you permit me to be heard notwithstanding our notice stated. I have not even received the proceedings, the readings,
Yes.
but my Lord, we are under instructions to be proactive so as to ensure speedy disposal of these matters.
That's the spirit, yes.
Yes, my Lord, so kindly permit me to come on record, notwithstanding that my paperwork has not been finalized.
On the promise that you are going to regularize that position and file your notice,
Yes, my Lord.
undertaking to file notice of appointment for number 1 and 2, right?
Yes, my Lord.
Okay. Who else is there? Is there an interested party in the matter?
Yes, Your Lordship.
Yes, 1 and 2. Have you read this up?
Yes, Your Lordship, we served them electronically
Great.
on 31st of May.
Okay. Is there anyone for EACC, Ethics and Anti-Corruption Commission, and DCI? No. No appearance for IP 1 and 2. Yes. Where are we now? Yes. That's the first of May.
And my Lord, for purposes of the record, we have filed a preliminary objection.
Yes. Dated when?
Dated today, the 2nd of June.
Okay. Yes.
My Lord, our PO is on the question of jurisdiction.
Here things have?
Yes, Your Lordship. Yes,
Here,
Yes.
Yes.
my Lord, the question of jurisdiction subject to guidance of the everything else, so he directly cannot the studio, it should not take more than 5 to 10 minutes,
Yes.
and then proceed as direct.
Okay. And Mr. who? Mr. Charles Mogera, before I hear the petitioner?
Yes, my Lord.
Mm-hmm.
My Lord, my instructions are that this matter is touching on eligibility for election or appointment to
Yes.
the office.
Yes.
Elections scheduled for 9th of August.
Yes.
And my Lord, to that extent, there have been filed various other matters
Yes.
related to the same issue.
Yes.
My Lord, if you permit me, I can read the matter. They are not very many. I think they are about 6. I'll just give the case numbers.
Yes. You say there are 6 other matters.
Yes, my prediction is 6 or 7.
6 or 7. That's okay. We can take the number. We are taking your word. I'll hear the response from their side. You say there are 6 other matters.
Yes, my lord.
Yes.
And the leadership, the Chief Justice, has already constituted an expanded bench.
Yes.
Examine these matters, my lord.
Yes.
And to avoid a multiplicity of suits and divergent judgments.
Yes. Yes.
So I will be doing on behalf of the first and the second respondents.
Yes.
But the matter will be referred to the Chief Justice
Yes.
for further directions so that it is taken before the expanded bench which is being presided by Justice David Mayanja,
Yes.
sitting with Justice Chacha Muta and the Lady Justice Mure Lando.
Yes.
Those will be my instructions for now, my lord.
Okay. I will hear then Mr. Otieno.
Your Lordship, we do confirm that you are served with the notice of preliminary objection.
We serve with the PO.
Yes, Your Lordship. Equally, I've managed to peruse the PO,
Yes.
and I believe I can respond to it orally.
The PO. Yes.
And I'm also ready to proceed with canvassing my application.
Yes.
On the sentiment,
Now, is other than the PO, Mr. Giancolo's plan, have they called any response on the past?
no, Your Lordship.
My lord,
The application
my lord,
cannot
we
be
are
had.
No.
and the reason is because we want to start today morning. We have actually had to put all the stocks, even to manage to put in the deal.
So then the application will not be ready, Mr. Otieno.
Your Lordship, you should go on record that the third respondent was served on 31st, and there's an affidavit of service to that effect. Yes, which was filed today, signed by myself.
I hope that everybody understands that if sure you file first, and there was a holiday between.
Yes,
You cannot blame the respondent.
I
for
cannot
not
blame
having-
them, but it should be on record that they were served. Owing to the strict timelines, the court directed us to do so. Yes, Your
So
Lordship.
one thing we are sure of now is that the application itself cannot be had. What can be had is the preliminary objection. Is that correct? Because there is no response to the application.
Your Lordship, the application was set for inter partes hearing today by this honorable court. So I will stand guided by the court's directions, but I believe that what is coming up for hearing today is my application dated 31st of May 2022. So where, if there is no response, then I believe the PO can be treated as a response. As a
Let me
stand.
hear your comments on Mr. Mongela's position.
Yes, Your Lordship. I'm aware of the directive by the Lady Chief Justice
Yes.
on formulation of the said bench.
Yes.
However, I'm not privy to the matters which have been filed, but I'm aware that the issues of eligibility, the Lady Justice Lady Justice Martha Koome directed that the same be had by the said bench.
Yes. Is this an issue of eligibility?
Yes, this is also an issue of eligibility.
Being handled by the expanded bench.
Yes, Your Lordship.
So what is your reaction to Mr. Mongela's application?
Your Lordship, my reaction
Will
is
you be
that...
able to take it on now if I was to proceed?
Taking on?
You have heard what he has said.
Yes.
There is a response required by the petitioner. It's your case.
Yes, Your
Are
Lordship.
you able to respond to what he says?
Yes, I'm able to
Or are
respond.
you conceding that I should take the file?
No, I'm not conceding because each case is peculiar in its own nature. And
So you'll be able to respond to that?
yes, Your Lordship.
Okay. And Mr. Did I hear you, Mr. Giancolo, on the matter of think it was said later. On the issue of raised by Mr. Mongela, for reference to the CJ.
I have asked Mr. Mungela,
Yes.
and perhaps I'm not hostile to his suggestion.
Yes.
Our proposal is if, assuming we are right on the question of jurisdiction,
Yes.
then you must drop your pen in that order to refer the case
Yes.
together. There is no such power.
Yes.
So that the question of jurisdiction must be determined first. It is only at the determined that you are jurisdiction that then you can issue directions on whether the matter will proceed separately
Yes.
or it will be forwarded to a expanded bench. In principle, I have no objection to Mr. Mungela's suggestion, saying of course for jurisdiction must be established first.
Mr. Mongela, it is your application. Before I give directions, yes.
I would like to agree that where a PO has been taken, takes precedence or the other applications, hearings, mentions. Incidentally, my lord, perhaps you could determine that question as to whether there is a matter before you give up or be directed to the expanded bench. Or maybe you determine those matters simultaneously. I don't know, as you direct my lord.
Okay, Mr. Otieno confirms you are for the petitioner and you are ready to proceed with the PO.
Yes, Your Lordship.
I think we should take the PO now. Then the outcome of the PO will determine two things: whether the matter will stay with me or it will be taken to Nairobi. But before we reach there, we have to agree whether there is a case for me to transfer or to deal with. That's correct?
That's correct,
So
Your Lordship.
Mr. Diancol will ask the application. You say how much time do you need?
My lord, I don't need more than 5 to 10 minutes.
Mr. Diancol will take 10 minutes to make the PO. I will allow Mr. Mongela, who appears to support that side. Then you are going to respond to them, both of them in full. Right?
Yes,
Is that okay?
that is okay.
So we take 10. Mr. Mongela will take 5 because you are supporting the PO by Mr. Diancol. Then you will have your full 15 minutes.
That's okay.
That's a good time management.
It is.
Anything else I need to address before we go?
That's fine, yeah.
Okay, I'll set my watch at 3 o'clock and Mr. Diancol will proceed when he's ready.
My lord, the PO is that this court has no jurisdiction for the reason that when you produce the application before you specifically pre-export the thing,
Point me to the PO, what was there in my pocket? Yes, I do. Please proceed.
if the lord, if you see the difference between on the page of the application before you
Yes,
pre-export the thing,
yes.
it is instituted as the nomination of candidates for election. According to Article 88, Clause 4, Paragraph E of our Constitution.
884E.
Yes, my lord.
Yes.
The jurisdiction via a dispute such as the one in the application before you
Yes.
is vested in the IEBC.
Yes.
It follows therefore, my lord, that this court has no jurisdiction to hear all the application after petition. This position, my lord, has been confirmed in countless decisions.
Yes.
We have cited at least 3 of them in the PO.
You have imputed the authorities on the PO?
Yes, we have cited them. They are listed.
Yes.
They include Nairobi petition number 3,
Yes.
They
Yes.
include the European petition number 399 of 2016
Yes.
and the decision from the Supreme Court in application number 2 of 2011.
Yes.
The draft of the first decision, my lord, was re-election disputes, which include the dispute of the type before you,
Yes.
have been addressed at the appropriate forum
Yes.
before a party can come to court.
That is the decision of 356
How 356, my lord.
of 2012.
Yes.
Yes.
The draft of the decision in number B, review of our preliminary objection is that the jurisdiction of a court cannot be expanded
Yes.
by judicial grant or interpretation. A court either asks or it doesn't have jurisdiction. There is no middle ground to that issue.
Yes.
The draft of the third decision, my lord, was that dispute of the IP point
Yes.
must be taken to the IADC as well to coordinate for to hit the Constitution.
Number 399 is on the article itself.
Yes, my lord.
399 of 2016.
And even 356 is on the article itself, my lord.
Yes.
Secondly, my lord, the question before you,
Yes.
whether you style it as nomination, whether you style it as eligibility,
Yes.
at the end of the day, it is a question of whether the dad responded as a degree from the university recognized education. That question, my lord, which takes me to paragraph 5 of the preliminary objection,
Yes.
was determined on the 18th of May in the year 2018, about 7 years ago,
In 2018.
by the Honorable Mr. Justice Odunga on 18th May 2018,
Yes.
in some 3 consolidated cases,
Yes.
which are cited in paragraph 5 of our preliminary objection.
Involving the respondent himself, that respondent.
Yes, my lord. Involving the respondent and some of the of course involve the IDC, if you involve the ESCC and C, in this case before you, if you also involve the DCIYC, cited before you.
Petition number 7, that's right?
Yes, my lord.
Number 7 of 2018.
That issue was determined about the land respondent
Yes.
by the Honorable Mr. Justice Odunga.
Yes.
That decision, my lord, is of the type we call decisions in rem. Under section 44 of our Evidence Act. To the extent that it is a decision in rem, it is binding not only of the parties that have appeared before Justice Odunga,
Yes.
but the entire world. A consequence that flows from that, my lord, is that the issue raised before you is res judicata. And the issue being res judicata, my lord, according to section 7 of the civil procedure, this court is barred by section from the garnish. As well as becomes the jurisdiction issue, the section 7 says, no court shall be here, including your court, my lord.
Yes.
Number 8, which leads to the issue raised by Mr. Ongela,
Yes.
and this leads to the point.
Is petition E122?
There is petition number E122 currently pending before your brother,
Yes.
is the Justice Murima. This petition was filed way back in May,
Yes.
and the parties have appeared before Justice Murima, I believe, 2 or 3 times now.
Yes. Yes.
And in the schedule, the parties have filed their submissions
Is the third respondent a party in that suit?
Yes, he is a party, my lord. And that being the case, my lord, even if we were to assume we are wrong
Yes.
on Article 88,
Yes.
and even if we were to assume we are wrong that the matter is res judicata,
Yes.
it will still follow that this matter is the sub judice to the extent that another court is immediately from it. And that brings us to section 6, my lord, of the Civil Procedure Act,
Yes.
which says that no head shall be taken. It is an injunction against the court proceeding
Yes.
until the previously filed suits, which include provision number 157, Mr. Magamba mentioned.
Yes.
So by law, again, my lord, there is no step we can take even if we were wrong with jurisdiction. According to section 6 of the Civil Procedure Act,
Yes.
the court will not proceed or either of the application or the petition.
Yes.
Number 10, my lord,
Yes.
it is common ground and it is below dispute that the land resident has been a state officer for many years. It cannot be that the petitioner just discovered that the 6 hours the nomination that he doesn't have the eligibility. He must amount the rule that says including aids the vigilant,
Yes.
not the ignorant, wait until the last minute. Lastly, my lord,
Yes.
it is common ground that the nominations are due to take place 48 hours from now. The order you're being asked to do the application
Yes.
will be an order that would have the effect of preventing the third respondent from participating in an election, which would mean what the application is actually seeking is a final order. It is a rule, my lord, which I hope doesn't require much disputation,
Yes.
that says a court cannot grant an order that is in the nature of a final relief in an interlocutory application.
Yes.
Again, the reason my lord, the implication is that even if you are wrong on all the things I've told you previously,
Yes.
the kind of relief being sought cannot issue if its defendant will be irreversibly prejudiced. The third respondent, before the substantive hearing of the petition itself, he offends the application of the rule against giving final orders
Yes.
in interlocutory proceedings.
Yes.
This proposition, my lord, is to be found in very many authorities.
Yes.
I have tried just one before you, and I regret the circumstances under which we read was here before you have not allowed me to play all these decisions before you.
Yes.
It is a civil case number E121 of 2018
2015, yes.
between Oksana Investment Supplies Limited
Sana.
and Alice Wanjiro Wamoya. It was a matter before your sister, Mrs. Mary Cassandra. And why this decision is important, my love, is on the fact
Yes.
a place who was aware or should have been aware
Yes.
of the need to approach the court in time,
Yes.
waited for 10 months and every
Yes.
And the court received for two reasons. One, because he was sitting in interlocutory proceedings
Yes.
in the nature of a final order.
Yes.
And number two, for the reason that the applicant had been indolent for 10 months.
Yes.
And for all these reasons, my Lord, given the relief being sought in the application, it is discretionary relief independent.
Yes.
It is our very humble submission that this application before you does not meet the legal threshold of the grant of the relief that is seeks.
Yes.
And in the event, both the application and the petition
Yes.
are fulfilled by operation of the law for want of limitation or offending the rules and holding them unpleasantly. And for that reason, my Lord, we very aptly ask Francis of this meeting, not just the application before you, but then the line petition. And if that prayer does not find favor with my Lord, the request that you don't grant any petition to relief, let the matter be canvassed for the intent and the appropriate time. Yes, I call it. Probably. And that, my Lord, I may have prayed to you that at some point I will pass a flight to address some national duty, so I may have the appropriate time depending on how long my body is stay. I may have to seek you without to step up, and then my colleague will do the response. Thank you, ma'am.
You have a company of sufficient number of lawyers, so we can excuse Mr. Diancolo at this point.
Yes.
You are excused whenever you need to go, the others will take charge.
Much obliged, ma'am.
Mr. Charles Mungela?
My Lord, for clarity purposes,
Yes.
the first and the second respondent neither supports nor opposes the preliminary objection. For the very reason, my Lord, that we are not standing the pleadings,
Yes.
we are also not standing the preliminary objection,
Yes.
and will therefore be leaving it to your determination, my Lord.
Okay. We have had counsel for the objector, Mr. Otieno.
Yes, Your Lordship. In response to my senior sentiments, I would first wish to point out that the
Are you able to
application...
hear Mr. Otieno online?
Yes, I can hear you, my Lord.
And Mr. Diancolo?
Thank you.
And the others who are with him?
I can hear my Lord, but if I have to improve on his joint projection, I think his challenge is the network limit.
Are you able to place that on here a little bit? We are getting the mic nearer to the bed, to the bar. Yes, proceed.
Your Lordship, in response to the submissions by my senior, Dr. Mudomi,
Yes.
I would like to point it out to the court that the application before you
Yes.
is not an application on a nomination dispute.
Nomination dispute, yes.
Your Lordship, what we are challenging is the eligibility or the qualifications of the third respondent to vie for the position of the governor for the Greater County of Meru,
Qualification of the third respondent
to vie for the position
for the position
of governor for the Greater County of Meru.
of governor.
Yes, Your Lordship. As espoused under Section 22(2) of the Elections Act, which
Section 22.
22 subsection 2 of the Elections Act, which requires one to have a degree, a valid degree which is recognized in Kenya.
It requires a candidate,
Candidate, yes, Your Lordship.
possess
A valid degree,
a valid
degree certificate,
degree certificate
recognized in Kenya.
in Kenya.
Yes, Your Lordship.
Yes.
These sentiments are also echoed under Article 182 of the Constitution,
I also refer to 182.
180 sub-article 2.
180.
Yes, sub-article 2 of the Constitution,
Yes.
and Article 193 sub-article 1 of the Constitution.
193.
Yes, Your Lordship.
Yes.
Your Lordship, our application is also hinged on Section 165, Article 165, sub-article 2B, sub-article 3B.
The decision of the court.
Yes, Your Lordship, which grants this court jurisdiction to entertain or determine the question as to whether a right or fundamental freedom in the Bill of Rights has been denied, violated, or threatened.
Yes.
Your Lordship, I would also like to argue that the PO which has been placed before this court is not on a pure point of law. The tests to be satisfied before a PO can be argued are that, one, it should raise a pure point of law. Secondly, it is argued on the assumption that all facts pleaded are correct, and it cannot be raised if any fact has to be ascertained or what is sought is an exercise of judicial authority.
You are referring to the Mukisa district?
Yes, Your Lordship.
Yeah.
Your Lordship, Council has taken you through or has mentioned that the issue here is whether the degree which is in possession of the third respondent is genuine or if he possesses a degree. That is a factual issue which this court has to refer.
Take that again. You say
Your Lordship,
whether the degree
which the third respondent possesses is valid or not. And Council?
That is the question you said before the court?
Yes, Your Lordship. And Council for the third respondent has indicated that the said degree is genuine and indeed the third respondent possesses that. This court cannot determine that without going into the facts. And where facts have to be determined, then the PO loses its bearing in matters raising a pure point of law. Your Lordship, Council has also cited that the instant application and petition res judicata, we beg to differ for reasons that this application or the petition before you has not been determined to finality. And in any case, the petition which Council has been referring to, wherein your brother Justice Odunga delivered a judgment on 18th of May 2018.
Petition number?
Petition number, it is number 7.
Number 7 of 2018?
Yes, Your Lordship.
Yes.
Petition number 7 of
Paragraph 5 of this PO?
Of 2018. Yes, Your Lordship.
Yes.
They have referred and urged this court to dismiss our application based on the fact that this is a matter which was determined in finality.
Yes.
We beg to differ, Your Lordship, for reasons that what was before court or what the court determined was the process in which Nairobi University, which was the subject institution in the suit, with regard to the process in which it undertook to cancel the third respondent's degree certificate in Bachelor's of Law. Therefore, the court did not determine whether the
Is the decision by Odunga in a way here?
Yes, it is there, Your Lordship. Yeah.
Take it that you are going to read it.
Yes, Your Lordship. It was just concerned with the process. Your Lordship, we've also been informed that the decision is in rem. I'm sure this court is aware of what a decision in rem means, since a decision in rem does not impose liability on any person. And as such, you cannot say that it was a decision in finality. Your Lordship.
Take that again so that everyone is clear. And
Your Lordship, counsel has said that the decision which your brother Justice Odunga made was a decision in rem, implying that it is a decision which will bind this court.
And everybody in the world.
Yes, Your Lordship. We beg to differ that a decision in rem does not in any way impose any personal liability on anyone, but just adjudicates the interests of all persons in a specific field. And in this instant case, it was the process which was undertaken by the Nairobi University cancellation of the third respondent's degree.
So that my stakeholders understand you, are you able to tell them what decision in rem is? Not in Latin now, in common language?
A decision in rem, if I'm to simplify, is a decision which has been undertaken by a body, the judicial authority.
The state of things about something.
Yes, Your
Is
Lord.
a final order.
It is
For
not.
example, if I said in this court that the respondent,
Yes.
that respondent you say is who? Franklin Medical Linturi.
Yes, Your Lord.
If I say that Franklin Medical Linturi has a valid law degree,
Yes.
that is a general,
Yes, Your Lordship.
it gives him status that he has achieved that.
Yes, Your
It
Lordship.
will not be questioned by any other person in the world.
Yes, Your Lordship.
So,
However,
you tell me now that this, the question in Odunga's matter is not
yeah.
of that nature. That's what
The
it is.
question, yes, the question in Odunga's matter was on account of the process which the University of Nairobi undertook to cancel the third respondent's degree certificate.
It was the process.
It was only the process. And the court determined that that process was not in conformity with the law. And they were directed to conduct a fresh process in conformity with the law. But the court did not determine that the
They were
certificate
directed to perform,
to conduct a process
to conduct a process.
in conformity with the law. But the court did not determine.
So that they understand where they have to respond.
Yes, Your Lord. The court did not determine or state that the degree certificate obtained at Nairobi University was genuine.
Okay? And when the case was determined, what is the position then obtaining before the order of Judge?
The position before the order of Judge Odunga. It means the degree certificate which he has.
He still has it, isn't it?
Yes, yes.
It has not been nullified.
It hasn't been nullified. Yes, Your Lordship. But the court has to understand that our application and petition stem from the root cause, which begins at the secondary level. And it is also strike law that any process which was based on an illegality, whichever the outcome, that outcome is null and void.
You're saying the process of obtaining the degree.
Yes, the process of obtaining the degree was based on deceit. Since it is on deceit, since it is our contention that the KCSE certificate in possession of the third respondent is fault. And this has been explained elaborately at paragraph.
Is he arguing his application? Because no, I think that is not going to the application.
That's a valid point, Mr. Kibora.
It is a valid point. That one has been elaborately outlined at paragraph 9 and paragraph 10 of the petitioner's supporting affidavit.
You're saying you don't argue the application now. You're just responding to the field.
That's correct, Your Honor, Your Lordship. Then if I may proceed on the issue of sub judice, Your Lordship. It is strike law that where sub judice occurs, the matter in issue has to be substantively the same.
You are responding to the paragraph, paragraph 8, is it?
Yes, sub judice is paragraph
Of the PO?
paragraph 9, yes.
9?
Yes.
Yes.
Of the PO. Yes. Sub judice only arises where the matter is directly and substantially the same with the previously instituted suit between the same parties pending before the same court or a court with jurisdiction to determine. Your Lordship, there is no matter that has been placed before you that is directly or substantially the same with this one,
Substantially the same.
with this one, in terms of issues and parties, and any determination to that effect.
So the one that they cite there, High Court 122, what's the difference with this one?
I don't have, I do not have that specific case because it is not attached in my.
Not attached to the
So I cannot. Yes, it is not attached to the PU. Yes, Your Lordship, and if this court, by any chance, finds that indeed this matter is sub judice, the court cannot go on to dismiss the same, but in the interest of justice, either order a consolidation or stay one suit pending the hearing and
Do I have a
determination.
choice which one?
Pardon, Your Lordship?
Does the court have a choice which one to stay? Or is it already the same? What I do with the money?
Your Lordship, it is a matter of law, and that is provided under, according to Section 6 of the Civil Procedure Act, it is provided that where the court is faced with a situation where sub judice arises, then either the court stays one,
That means reading and misreading. Section 6 says which one does not proceed. It is a subsequent one.
yes, Your Lordship.
Huh?
That is what I
In
mean.
terms of time, it will be this one, isn't it?
That one is for the court to determine.
In mathematics and physics, Mr. Otieno,
Yes, Your Lordship.
one comes before the other.
Yes, Your
So
Lordship.
122 of this one here, of 22,
Yes, Your Lordship.
is before this. This one was filed on Wednesday.
Yes, Your Lordship. But as I said, I'm not privy to what was 22, 122, and 10.
And you submit that I would have a choice as which one to stay.
as it stands, if the issues, that is why I'm saying if the court finds that the matter is sub judice, then automatically the one which was filed earlier will take precedence. Yes, that is my argument. Yes, Your Lordship. Your Lordship, Council has also submitted that filing of this suit has been filed way after the third respondent has been in public service.
Delay in filing, yeah? That's what
Yes,
you said?
a delay in filing.
Yes.
But we wish to differ that the issue of whether the suit has been filed out of time or later, Your Lordship, is not an issue, because any petition or application based on Article 22 or any constitutional petition has no time limits for filing. And the Constitution empowers each and every citizen to move court appropriately whenever he or she feels that his rights, his constitutional rights have been violated and threatened. Yes. Your Lordship, Council has also stated that the application or petition is meant to bar the third respondent from contesting. Your Lordship, we beg to differ and say that this is an issue where the court is called upon to decide between private individual rights and the public interest at large. Your Lordship, we are talking about the whole county of Meru. This is someone who is going to lead the county of Meru. His private interest to bias governor cannot at any stage override the public interest. Your Lordship, you've also been told that what the orders we are seeking are orders in finality.
Yes.
Yes, Your Lordship. Our contention or our argument is that this court is empowered under Article 23(3), under Article 23, sub-Article 3(c) of the Constitution, and Rule 23 of the Constitution of Kenya, Protection of Rights and Fundamental Freedom, Practice and Procedure Rules 2013.
The rules you mean?
Yes, Your Lordship. To issue.
What rule?
Rule 23.
Rule 23.
Yes, Your Lordship.
Yes.
To issue appropriate reliefs, including a conservatory order, where the subject matter can be rendered or will be rendered nugatory if those orders are not issued. And for this reason, Your Lordship, we rely on the Nubian Rights Forum and two others versus Attorney General and 6 others, Child Welfare Society and 8 others, and the Center for Intellectual Property.
Did you supply a copy of that? What
I did
year
not
is it?
supply, Your Lordship. I'm going to cite the year and
What year we can look for it?
it is petitions number 56, 58, and 59 of 2019 EK land.
5, 6, 5, 8, and 9 of
2019.
2019. So it will be recorded in 2019 EKR.
Yes, Your Lordship.
Okay, we shall look it up. Yes, what?
With that, Your Lordship, I raise my submissions and urge this Honorable Court to dismiss the preliminary objection with costs to the petitioner. Thank you.
Okay, is Mr. Kianko still around, or do we have someone else?
Very briefly, my lord,
You are there? Yes, okay.
is on whether this is a dispute about
Prayer number 2 of this, of the application or the petition?
Of the prayer number 2, the second prayer, the application.
The application.
On whether the dispute again about nomination, my Lord, all the needs to go to the result of a certified agent. The result it was certified agent is the nomination is happening 2 days from now. And therefore, it is not correct that my lieutenant friend wants his own meetings. Or unless he just wants to play some history. When all is said and done, the matter before you is about nomination. And therefore it falls within Article 88, clause 4, paragraph E. What my Lord number 2.
Before you proceed, the issue of clearance of candidates, Mr. Mongela. Are you there, Mr. Mongela? That's your line?
Yes, my Lord, I'm there.
The issue of clearance of candidates is what is in common language nominations? Or is it something technical?
Let's say that it is at the level at which the IEBC, by the returning officer,
Yes.
certifies that the candidate is eligible to participate in the elections.
And that is the nomination stage.
Yes, my Lord.
And in your view, anything happening at that stage is a nomination dispute.
My Lord, that is why I was saying that the legal refraining
Yes.
from supporting or opposing them.
I did ask you to support anyone. Yes.
For clarity purposes, my Lord,
Yes.
it is indeed part of the electoral cycle, the nomination process.
Yes.
It starts with the receipt of those documents.
Yes.
When the IEBC and the returning officer are receiving those documents, they are actually conducting the nominations.
Yes.
If, for example, there is no other candidate, if a single candidate stands out, my Lord,
Yes.
that candidate will go through and oppose.
Yes.
So it is a nomination, my Lord.
I see. Do the rules, I don't have my election act here. Do the rules, Mr. Mungela, define what nominations are or the nomination process?
Yes, they do, my Lord. The law says that I'm ready to the rules.
Or the election act, a section of the election act.
I could be able to only to address from this matter in the morning before I need to do that.
Well, for now, I think I'll have to do with my own help because I have to give you a decision shortly. Okay, please, I have had Giancarlo say that this is a nomination dispute. Yes, go on.
My Lord, the question you asked is on Mongera.
Yes.
The question arises in Parliament corrected the problem recently.
Yes.
You commingle party primaries and nomination.
Yes.
And then in a few weeks, if not maybe 1 or 2 months ago,
Yes.
Parliament amended the Elections Act, clarifying which is which between the party primaries and the process, not being asked to follow. But our submission, my Lord, is was anticipated by them. So it is our view that the deal is properly before you and that it meets the threshold set out in the vis-a-vis case. In any event, my Lord, from the authorities we shared with you, this is not a factor in this title. It is not permitted before the court. But we can count how many times this deal was committed. Number three, my Lord, you were told that what was Linturi coming was not a question of whether the Linturi and the degree and therefore the matter before you is not present.
Yes.
We contest that view from the country. And for all you know, when you bring it to review the decision by the citizen ruler, you will note that there were three cases before you. Only that this decision is on the notification case.
I will allow Mr. Otieno to respond to that because you have raised the issue of Anderson and Anderson. So Otieno, you have a chance to respond. Proceed.
That's very enough. Then you were told that there was a question my Lord asked whether they called us the discretion on which to stay.
Yes.
Our answer is that the statute has already predetermined
Yes.
that it is the statute which is to be stayed, and in that case it will be the suit before you. You were told, my Lord, that there is no delay.
Yes.
The applicant before you is a registered voter in Meru County.
Yes.
It must be clear that by now he also accepts the Honorable Linturi has been the senator for the last 5 years.
Yes.
And it must be taken therefore that his Honorable Linturi needed a degree to become a senator. He was aware, or should have been aware. So again, it doesn't matter, my Lord, even for the senator, there is no way this guy can send you with a straight face that they are not going to delay.
When you point to the issue of the senator and the requirement for a degree, what section are you requiring? What section requires? Okay. So you are saying that the senator has been senator for the last so long, and therefore he must have been qualified?
Yes, according to the decision, we claim he was qualified because the matter was raised before Justice Odunga, and the case was in his favor.
And the applicant who is a voter in Meru County should have known.
Should have known there were things before Justice Odunga in the event. He should have known that he was the senator for Meru. For him to come to you 2 days to the nomination and to tell you he's not guilty of laches, in my view, it doesn't reflect well upon him.
Yes.
And that kind of my Lord, even if you are to see that we are almost ready,
Yes.
the fact that it's coming this late is a matter that we need to exercise of discretion in his favor. Because the order so from him is now that order that a party can claim to be entitled as of right. It is an order they are pursuing, and they are also explained that your discretion should be exercised in their favor. You want to do something about public interest.
Yes.
Our submission is that this is the biggest thing in the applicant's case, and specifically my Lord, it is not in the public interest wishing interlocutory orders at the tail end when the party has to have come much my Lord, and empower the priest to appropriate that it is not a kind of belief sought in their believing blasphemy, my Lord. If we are told that the petition will be rendered negative if you don't grant the application.
Yes.
Our suspicion is, one, it is not correct that the petition will be rendered negatively. Because the applicant still have the opportunity to present election petition before an election is won. After the results of the election are in the air, and he is able to persuade the court that the Honorable Linturi doesn't have the eligibility, doesn't have the degree, whichever you want it. So it is not true, right?
Yes.
But in the event we are wrong, my Lord, that it will be rendered negative,
Yes.
the person to be punished for that is not the Honorable Linturi. It is the petitioner who approaching the court and Thursday, when he had all the time moving in a manner that is fair, all the impressed people. And for those reasons, my Lord, we still very humbly beseech you to strike out this application and they are aligned with it.
Thank you. Mr. Otieno, I promised that I would hear you on the issue that Mr. Tiankoi raised in his reply, which was what? The issue of, yes, Anderson and Henderson. The issue that points which ought to have been taken, which are not taken, was judicial.
Your Lordship, if I may briefly answer that, I beg to differ with my senior's submissions in that respect, because, Your Lordship, what senior wants this court to understand is that the case which was determined by your brother Justice Odunga together with the three others,
Yes.
had the same issues, and what was the subject of those cases
Yes.
was the same subject which is before you here today. We differ and state that those are two distinct cases and of peculiar nature. This is because the issue which is before this court regarding the eligibility of the third respondent to vie for the position of the governor of the county of Nairobi has not been determined by any court. What the court pronounced itself on was the issue of the process, and which I still insist was the process which led to the cancellation of his degree certificate. Therefore, this application of instant petition cannot be rendered res judicata based on a determination which was made in regards to prerogative orders of judicial review. That's all, Your Worship.
Was it a judicial review, Martha?
No, the orders which were issued were judicial review in nature.
Judicial review, but it was a constitutional application?
Yes, Your Lordship. It was a constitutional application.
Petitions and the judicial review application, there were 3 cases.
Yes.
Yes, and the court will have time to look at the decision.
Take it that I'm going to read the decision.
Yes, Your
I'm just going to put it down and get along.
Yes, Your
Anything
Lordship.
else?
Your Lordship, I've also had counsel. What counsel is also, because I'd been stopped by this court when I tried to refer the court to our application. But counsel has severally referred this court to our application, which is filed in that court. In essence, counsel seems to be arguing against that application, whereas what we're dealing with is the petition. I beg and I humbly beseech this court to disregard.
Take it that this is a professional court.
Yes, Your Worship.
We meet on matters of law,
Most of them.
accordance with the progress of judicial disputes.
Most of like Your Worship.
But you see, as you make a submission, you may not fail to make a reference to a matter of fact.
I do understand, Your Worship.
So when they point me to prayer number this one, I require to see what the prayer says.
That's correct.
I'm not saying it is true or not true. We are looking at what you have come for. And what I have heard from both of you, the three sides, is that it's a matter of law.
Yes, Your Worship.
So my determination will be on the law applicable at this stage. Then I give appropriate direction. As regards Mr. Mongela's request, I think we have to leave it in abeyance.
Yes, Your Worship.
Because Mr. Mongela, you have not moved the forward to transfer or to refer the matter to the Honorable CPS. The question we determine first is whether this petition is properly before the High Court.
Yes, Your Worship.
Yeah?
That's correct.
Right. Does anybody else have anything before I give directions as to the ruling? Starting with Mr. Mongela.
Yes, my lord, you are asked to give us the act as defined in the nomination.
You have an answer now?
Yes, my lord, that's it.
Yes, we appreciate it. Time for learning all the time.
I don't look at the interpretation section
Of the Elections Act.
Elections Act number 24 of 2011.
Yes.
I know nomination means the submission to the commission of the name of a candidate in accordance with the Constitution and this Act.
The Constitution and the Act.
Yes, my lord, it goes on to state what the nomination date is.
Yes.
It says that in respect to an election,
Yes.
it means the day gazetted at least 6 days before an election by the commission
Yes.
for the nomination of candidates for that election.
Yes.
So my lord, he did what is coming up as a nomination.
So is there a gazette? Is it gazetted for my record?
Yes, my lord, the dates are even stated.
It's
You supply that gazette.
have been gazetted. What is the gazette number? Gazette number if you have it?
Yes, and the gazette has been issued, my lord, at the time, specific time, like it says.
Gazette and timeline. Do you have the gazette number?
I would have made it to my lord, can I kind of, my lord, request that I can this to you by first thing this morning?
You see, it will have to be, we are in session now, and everybody will have to see what you are giving me. You don't want to be accused of sneaking something.
Can you give me a few minutes, my lord, like 5-10 minutes?
To pull out, just refer to me, when was it done? We can pull it out, so that you say it in the presence and hearing of everyone. Gazette notice of what date, if you can get that.
It's applied to me, my lord, but unfortunately, they have not said
Okay. But your submission is that the Gazette has been issued with timelines for the clearance and nominations.
which is a 4th, 5th, and 6th, my lord.
For 4, 5, and 6.
Yes, my lord.
Okay, we'll take that. Anything else, Mr. Mongela?
Nothing else, my lord.
Thank you. And now I hear for the applicant. Or should I hear move up first before I hear you? You are the one who has brought the matter to court. Dr. Dinkol, anything that we need to deal with before I issue guidelines for ruling? Well, I intend to give you direction. I don't want to hold the IETC program, so I'll try to give a decision well before 3 o'clock tomorrow. It's, I think you are already excused by your colleagues, and we shall shall excuse you.
Much obliged.
Thank you. Mr. Otieno?
Your Lordship, if it were in my power, I would have loved the application addressed, but now that we have to deal with the PO, then I'll stand by the court's direction in respect to the matter.
Yes, I will look at the matter. Plant midnight oil. These days we don't have oil, but it still makes sense. Number 5. If I give my decision before hearing that other one, you see what will have happened? What? There will be no need perhaps to hear the other one. Yeah? So the two cannot, one cannot be read on before the other, before the arguments are online. So as soon as, or in the course of hearing of the other matter, I'll give a decision. And there is no harm, they are all affecting the 4th, 5th, and 6th. So even if I gave the decision last after arguments in number 5, it will still be within time. Right? So 2:30 tomorrow, no, 12:30, 1230 of tomorrow is the 3rd of June. And I thank everyone who has come to follow on this matter, including the press. These kind of cases are always matters of public interest, and it is our duty to do the best we can in the matter, under the Constitution and before God. May I wish everyone a good evening? Thank you very much.
Ni Wero TV.